Blandino?
He's coming in, Your Honor.
Good morning, all right, thank you.
Kim Blandino, appearing pro se for Kim Blandino. I see that's Linda Marie Bell as judge, but you don't look like Linda Marie Bell.
I'm not Linda Marie Bell, my name is Christina Silva, good morning.
Christina Silva?
Yes,
You're a district court judge from this district?
I am, I was appointed earlier in 2019.
Do you have a written request under DCR 18 to appear?
No, and I do not need one, so I'm gonna start to ask some questions, and then I'm gonna turn to you. I'll have some questions for you specifically, so hold that thought. Mr. Dickinson, do you have an update for me?
Yes, Your Honor, this is the 8th time that we've appeared in competency court with the defendant. To this day, he has failed to get any of the required evaluations that he's been ordered to
I
get.
object.
And he's also, seems to have harassed the psychiatrists and psychologists who he's been referred to.
That's a lie.
This is an
Mr.
issue.
Blandino, you'll have an opportunity to talk, let him finish
Can
the
I tell
record, and
you,
you'll have an
will I have
opportunity
a
to talk.
chance to represent that he's lying?
Hold on, Mr. Blandino, let him finish talking, and I'll talk to you.
And I base that off of emails that I've received that are coming to the court regarding the way that he's showing up at their offices and refused dates that he's been given by them to come in and evaluate. With that, I think that the only way to remedy this issue is just by putting him in custody and having him evaluated in custody. This is the 8th time, we've asked multiple times to have the defendant placed in custody to be evaluated, in addition to the fact that he's continued his criminal behavior of illegally contacting judges in an extortive manner while he's been out and in competency court in this case. So with that, Your Honor, the state's request is just to remand the defendant today to get the process moving.
All right, thank you. Mr. Blandino, why haven't you gone to the appointments that were scheduled for you?
I have. I've gone. I've got a card here. They refused to see me. They said they couldn't do it within the time frame that you allotted. He's lying 3 times over, and I'm going to file a bar complaint if he doesn't give an apology. He lied when he said he tried to have me remanded. He put pressure on my house arrest officer to arrest me before coming to court. Then when he tried to have me remanded, when I say he, district attorney's office, but Michael Dickerson is an embarrassment to the bar. And I have showed up at all the requirements. As a matter of fact, the order that you see by Linda Marquis ordering me to go within 7 days and make an appointment, I was there I called that very moment I got home and then went to their office at 3. Now he wants to take my appearance at their office as somehow some bad conduct or bad acting
Well,
on
Mr.
his
Blandino,
part.
did you have an appointment, or did you just show up?
I told him, look, I wanted to see the office and then see you, and I want to get this appointment scheduled as soon as possible. They said, we can't do anything until we talk to the doctors.
Okay.
At 3 o'clock when I went down there, and I have this all documented, I've got a copy for the DA and I have a copy for the judge, and I demand that you take judicial notice of this, because if you go ahead and do this horrible thing that he's recommending be done, based on lies, then here's the DA's copy.
Well, Mr. Blandino, hold on, let's back up a little bit. So you went down there without an appointment, is that correct?
No. The judge told me
No. Answer my question. You went down to the doctor's office without an appointment because you were trying to get one, is that correct?
Well, yeah, but I called first, and then I said, I'll come down at 3 o'clock. She made no objection. She said, no, don't come down here or anything. Went down there. I've got a witness in court right here, Chris Cave, that acknowledges that. He took business cards and such, and in good faith, I wanted to see that the office was clean. There weren't any health violations or anything such as that, and it was what I was going to appear for an appointment. Then I scheduled an appointment for the 26th. Everything seemed good. They emailed me, and I've got a copy of this stuff. Now this is labeled me, but here's the emails back and forth. If I can approach?
No.
No, you cannot.
Can the bailiff bring this to you?
Sure.
Yeah. This is an email, and then this latest card. They didn't formally tell me this appointment was canceled on the 26th, so I went down there, and now he's again, the district attorney's trying to again say that this is somehow bad behavior on my part. This is absolute due diligence on my part to make sure that they comply with what they were ordered to. But they're telling me that because this court, by order, gave a 20th date, they can't help me. So.
Okay,
you
hold on,
can't-
now let me review the documents you gave me, all right?
Okay.
So hold on.
You give me an order to appear?
Mr. Blandino.
Oh, I'm sorry.
Please wait until I'm finished
Okay.
reviewing the document, thank you.
You do have the marquee order, right?
I do.
Okay. Thank you. I was precluded from.
Mr. Blandino, hold on,
I'm
I'm still
sorry.
reviewing.
I've got other documents.
Mr.
too.
Blandino,
Yeah,
hold on.
well, I'm trying to stay out of jail, so excuse me if I'm a little bit.
And I appreciate that, but you're not gonna do yourself any favors by not letting me finish reviewing this, okay?
Yeah.
All right, I have reviewed a number of documents for the record. The first is an email, the 3-page email with some requests and email exchanges with what appears to be an individual with the state of Nevada, specifically the Lake Crossing Center. I reviewed a second email to Green Valley Psychiatric Associates. It seems to be kind of a cut and paste of a couple of.
Well, it's all the
Mr.
replies.
Hold on. A cut and paste of replies with an email exchange that previously went on in the month of December.
Yeah, just
And
for
attached to-
clarification, though, it's not cut and
Mr. Blandino, let me
paste.
finish putting this on
Okay.
record. Which attached to that is an order, the order that Mr. Blandino is referencing for the defendant to be examined. I also have a copy of a business card with a note that Mr. Blandino showed for an appointment on 12/26 at 7:45, but the appointment was canceled due to the time limits of the report being due on 12/20. And attached to that is an email exchange between Mr. Blandino and an attorney for the court, Mr. Liescas.
Yeah, he's staff counsel for the administrator's office.
Okay.
They, Denise Baker and Denise Parker of the specialty courts said that I would have to communicate to them. They refused to communicate with me. I've been absolutely due diligent on behalf of my client, which is me, Kim Blandino, as I'm representing myself.
Okay,
As an
well,
officer of the
Mr.
court,
Blandino, let me ask you this question.
Yeah.
Why did you not go to the appointments on December 11th and December 16th?
they never sent me any appointments for those. Where are you seeing the appointment for December 11th, December 16th? They never sent any appointments.
Well, the information I have is that you declined appointments on December 11th and December 16th. And I don't know if you declined them
No,
or
no,
you
no,
just
I did
refused
not.
to be evaluated. All right, so let me ask where that information is coming from. Hold that thought. Please don't interrupt. Mr. Dickinson, do you know where the dates of December 12th and December 16th came from?
I believe those came from the staff or the doctors that had emailed the court, let the court know that we offered Mr. Blandino, or they offered Mr. Blandino those dates. He said those dates wouldn't work for him.
This is not true, Judge.
Hold on, like I said, don't interrupt. Let me
Yeah.
ask, and then I'll ask you your questions.
That's my understanding of that situation.
That,
Okay, all right.
all he has is hearsay to go on. And if you're going to put me in jail, I demand an evidentiary hearing, because I can get those people on the stand and verify. If they give me those dates, I would have definitely filed an emergency petition with the Nevada Supreme Court to try and stop this. But if I couldn't get it, then I would have
Well, that
complied with
doesn't
those
make any
dates.
sense. Why would you file an emergency petition if you were ordered to go get an evaluation done and then were ordered to
Oh, well,
go
it
home
makes
to-
perfect sense if you understand the double jeopardy clause of the United States Constitution. I've already been punished. I've got this ankle bracelet on here, and I've been under punitive house arrest. I've been punished for the very crimes that I'm being charged with. Now, under Desimone 2, which is Desimone versus State, come back from the U.S. Supreme Court, if you have been punished already, you cannot be punished again, and therefore it would moot any competency proceedings or even any charges going forward. I've been denied my religious beliefs and practices. to take E.B. Pendergraft on religious excursions because I'm not a member of an organized religion, Mormon, Jehovah's Witness, you name them, Catholic, whatever. Because I have particular and peculiar religious beliefs and practices, I've been denied to take her. I'm being treated worse than if I were in the Clark County Detention Center. There's been punitive action here. I've got a 6 p.m. to 6 a.m. curfew. This statute has not been reviewed by the Nevada Supreme Court or the federal courts, but this statute where a judge is allowed to put somebody under punitive house arrest prior to being convicted in any way will not stand constitutional scrutiny. And I can show with all the documentation, as you can see from those emails, I document what I do. And that email that you cursorily read, it doesn't say anything about an 11th or appointment. That they said we can't do it within the time frame. They never told me about those appointments. Not once. I don't know where he's getting that information. I know that Mr. Dickerson has lied to this court before. He said when he tried to have me thrown in jail the last time, that I told my house arrest officer I was going to drop off some process with Talia Williams, who was the pro tem judge in the Justice Court. And I asked him, and he gave me permission to go. If he would have said, no, Kim, you can't go, I would not have gone. But yet, he lied in open court. Now, maybe based on hearsay that he was taking.
This defendant right here is on house arrest as a privilege, not a punishment.
I understand, Mr. Dickerson, I understand that, but we're also not gonna engage in a back and forth.
I'm on house arrest and $50,000 bail.
That happens, Mr. Blandino, when it comes to court proceedings, and.
But I'm saying this court has never approved that. They've never reviewed that. And you have surprised me, Judge, because I thought Linda Bell was gonna be here on the bench here. I have a right under NRS 1.230, 1.235, not to be surprised by a judge. I don't know if there's any conflicting issues on which I might need to file a motion to disqualify against you. This motion to disqualify has not been adjudicated yet. Do you see on the record anywhere that it's been adjudicated?
It has not, but I'm not Ms. Bell. So hold that thought. Mr. Dickerson, is his house arrest officer present in the courtroom?
I don't believe
No.
house arrest
Okay.
officers present.
Do we have any information regarding any house arrest issues?
Well, we addressed it at the last hearing, or 2 hearings ago.
Please
We
tell me that.
filed a motion to.
Marquis
remand.
denied that though on the record, Judge.
Hold on, but I'm asking for some
He
history
denied
because
the
I'm
remand. If
new.
you're gonna ask, if you
Mr.
said that's-
Blandino, I'm gonna ask you to please be quiet because I need to answer some questions.
I'm
so
sorry,
we can
I
address your
apologize.
case, all right?
Essentially, the issue was that Mr. Blandino had told his house arrest officer that he was gonna go to an attorney's office to drop off some paperwork.
Right.
What it sounds like he didn't tell his house arrest officer was that attorney was the pro tem judge that was sitting in justice court over his case and the paperwork that he was going to drop off, but there was extorted paperwork similar to that is the issue in this case.
And was that motion to remand denied by Judge Marquis?
It was denied in the written order. That's why I asked if you had that Marquis order.
I'm going through the docket, Mr. Blandino, but I need you to stop interrupting me. We'll make this process faster.
I can
Was that
direct you to
denied,
the
Mr.
It was denied with additional conditions added to his release, that being no contact with Ms. Williams, no contact with any judge privately, no contact with any judge without express written order by the district court, and that he can't file anything without express district court approval.
Was he declared a fictitious litigant at that point?
He has been previously.
That is on appeal with the Nevada Supreme Court, case number 76794. Briefing has been initiated by me, waiting for a decision. A responsive brief is not due unless the Supreme Court so directs. Because of that vexatious litigant order, I've been only able to make representations orally in this court, except in the unique exception where Judge Levitt allowed the motion to disqualify to be filed. But when I went before Marquis to file it, she wouldn't receive it in court. Was not file stamped. To this date, it's not file stamped, which caused me to file this or submit a notice.
So,
Under
Mr.
Sullivan-
Blandino, did you attempt to contact Judge Marquis after that hearing?
No. Well, no, I submitted the motion to disqualify as the vexatious litigant order says to the chief judge. Now, I relied on the chief judge, his law clerk, Wes, who took over for Benjamin Nemec. And I said, hey, look, I want to see if I can get approval to file this. Unbeknownst to me, he went and filed it without bringing it back to me because the certificate of service was signed in advance, figuring I'd be able to file this in open court. And this is the part of the problem that we have here, Judge. every one of you judges are showing favoritism toward the district attorneys. You let them file stuff on the very day of court. I get 5 minutes to look at it. That remand thing was given to me about 10 minutes before court. I get a cursory view of it, and then the judge rules on that without allowing me to do any kind of opposition. This motion to disqualify, I put in a notice, it's still under review. Wes couldn't tell me yesterday, that's Judge Bell's law clerk, who's reviewing it, or when, or under what criteria. The Sullivan versus District Court is very clear. When I put this thing in, it has to be marked received, which it wasn't. We have no chain of custody as to this document. It was filed by someone else other than me. Of course, I'm restrained from coming to the RJC, except when I have court appearances. So, I mean, there's just a slew of problems here because as representing my client, which is myself, I have to be zealously and vigorously defending him and requiring due process to be followed substantively as well as procedurally. The U.S. Supreme Court has said over and over again, procedural due process is every bit as important as substantive due process. So, to protect my client's rights, I'm going to demand that the court and all the officers dot every I and cross every T because this protects others that come from behind me. Now Miranda, he wasn't a good guy, but the Miranda warning we have is due to a guy that said, hey, I was abused in my rights. And there's something in the Constitution that mandates that. However, you know, apparently the problem is, if you see from that card, they said they were unable to comply with the 20 dates. They were unable to comply, Judge, what you were just given. It didn't come down to any misbehavior on my part. So he's trying to shoe in, the district attorney here for the record, is trying to shoehorn in somehow that I had 11th and 16th date and make me look like I'm not diligent in what I've done. And then when I am diligent, go down to the office to appear to show, hey, here I am, ready, what do you want to do? He tries to interpret that as misbehavior, like I'm harassing them.
Okay, hold on, Mr. Blandino.
It's damned if you do, damned if you don't.
Mr. Blandino,
Yes.
listen to me. The challenge is, and based on my review of this email exchange, you want to set your competency evaluation based on the dates you want to go and at the schedule you want to set it at. And that's just not, and you know.
No, that's not true.
Well, I'm looking at this and there's multiple contacts. You admit in this email, as an example, that you made multiple phone calls wanting to be seen. You hadn't heard back. It had only been a day since you placed the call. You were submitting repeated phone calls based on what I'm interpreting here. It's a little bit difficult to read some of the things that are submitted.
Yeah, then that's why an evidentiary hearing, if you go to put me in jail without an evidentiary hearing, you will be violating fundamental due process because you're trying to make some kind of factual determination based on this and not the evidence of the witnesses and evidence that could be produced at any evidentiary hearing. I tell you that I did everything due diligent without being harassing in any way. They never gave me those dates. If they would have given me those dates, I would have complied with those dates and or asked for an emergency petition emergency motion from the Nevada Supreme Court to stay this because of my double jeopardy claims. Now, they gave an order, Judge Marquis gave an order that I was supposed to do one within 27th day, but you see that card shows that they were still locked into this somehow, this 26th date. Somehow Marquis didn't get the order down to them or something because I complied with what they said. They never reset any new appointments. Now this was at the December, what was the date on that card there?
On the card?
Well, I'm sorry, on the date of the Marquis order. Because see, that's the thing, if you're gonna do this based on representations by the DA, he's lying. And I want him on the stand to show that he's lying.
You need to stop.
This gave me 7 days.
Mr. Blandino, listen to me.
I'm sorry.
I need you to stop making accusations that he's lying. Your train of thought is very difficult to follow. And so you're jumping from one thing to another, so I'm trying to keep us on track here.
Okay, here's what the order said.
I have it right in front of me, I see it.
It says within 7 days.
Mr. Blandino, I can read it.
Yeah.
I understand it says within 7 days. So
Yeah.
hold that thought, I have a question for Mr. Dickerson, okay?
Yes, Your Honor.
So I'm looking at the email exchanges. What evidence does the state have regarding his failure to comply with that 7-day order, other than
So,
He declined appointments.
what I have is that we were in court in front of Judge Markey on December sixth,
Right.
2019. She told him at that time that he had to get these.
Objection, Your Honor, this is irrelevant to the December
Mr.
20
Blandino,
order.
Mr. Blandino.
I don't have a DeLorean with
I
a
need
flux
to
capacitor to go back in
I
time.
let you talk, I'm going to let him talk.
Okay, I'm
Okay.
sorry.
Then
I need some water though, Judge, I'm not counting now.
Okay, we'll get you some water. Hold on.
She told him at that time that he had to do the evaluation within 7 days. And then I currently am looking at an email right now from Green Valley Psychiatric Associates to the court that was discussing Mr. Blandino. Specifically, it talks about how he had come into the office, he came to the office on December 6th, the day of that.
I'm sorry, objection, why isn't he giving you to read it?
Mr. Blandino, what did I say? Please stop interrupting. It will be faster. Let him finish talking and then you'll have an
Yeah, but
opportunity.
you're relying on his representations of what the email says.
I'll take a look at it in a
I
minute.
object to that.
And this is an email that the court has received, the court's administration, Your Honor. December 6th, ultimately, the exchange goes on there with, obviously, that not being the appropriate way to schedule the appointment. On Monday, December 9th, they contacted Mr. Blandino, told Mr. Blandino that they had December 11th available for him at 7:45. That was left in a voicemail. He called him back later that day, told him, no, that's not gonna work. They said, well,
I couldn't make that appointment.
we could do December 16th at 7:45 in the morning. He said he didn't want that one either. And then they
No.
told him the next available that they had was December 26th, 2019, which he was aware of at that time was after the December 20th date that was due for those particular reports. Well, that's the one that he decided to go for. I think it just shows exactly what the defendant's doing here. He's trying to drag this out. He's just trying to take this process and make a mockery of it because he thinks that he can run it the way that he wants to, but he is disregarding the court's order after order.
Mr. Dickerson, can I see that email you're referring to? For some reason, I don't have a copy of that.
Yes, Your Honor, if I can,
I object, I
email
need
it to
a
the
copy of
court,
that too.
Yes.
forward it.
I need a copy of that too.
Yeah, we'll print it
But
out.
look at this, Judge, he's going back in time to irrelevant matters. The December 20 is what's controlling here. It's irrelevant as to that. If he wants to make some prior bad acts claim, I object to that. This is what's at issue here. Obviously, the judge, I told the judge, I need a written order as to what I'm supposed to do. The evaluation process, which apparently attorneys throughout this entire 8th Judicial District and maybe even beyond think that somehow they should, it's in the interest to waive their client's rights to have a written order signed and filed by the judge. This is a court of record and a court of justice. As a court of record, I'm entitled to have a written order that says specifically what I'm required to do and when. And if I don't have that, then I'm up in the air because Rust versus Clark County School District is clear. An oral pronouncement from a bench or a minute order is incompetent for all, I'm using the wrong word, incompetent is wrong for, is not viable for any purposes. Has to be a written file order. So when Judge Markey agreed with me apparently and gave me this order the same day, on December 20, there's no possible way I can go back to December 11 and December 16 to make those appointments. So clearly, this is vindictive on the part of the district attorney's office to try and claim that those activities, which there was no prior written order, and I had a right to, because if I'm in contempt of an order, under NRS 22, order to show cause has to be made, it has to be done upon affidavit, sworn affidavit, not from lies from the district attorney's office made orally. There has to be a charging document for a contempt to be done. I went down there, they said, oh no, we got a December 20 order, so somehow they didn't get a copy of this. Because I tried to make, in good faith, make an appointment, I thought, well, maybe that 26th day appointment was still good and I can go make it. So I said, I better show up, because otherwise the district attorney's gonna lie and say, we didn't even try and make the
Okay,
26th
hold on, I'm gonna
appointment.
review this email.
Yeah, I need water desperately, I got cotton mouth.
Are you a doctor? Are you a doctor? Want me first? Don't you talk to me first?
Don't talk to him.
I know you. Okay, fine. Now you can come if I tell you. You go ahead.
It's distracting me.
Okay, whatever.
Can I get a copy of that to read? And I need that water really badly.
We're getting you water, Mr. Blandino.
Oh, thank you. I didn't hear that.
Yes, that's, so, hold on.
I know the court has a busy day, so when I speak so fast, I get cotton mouth and the adrenaline doesn't help either.
I understand, I've actually suffered from cotton mouth myself. I'll tell you though, talking only makes it worse. All right.
Thank you.
Is that different? Is yours different? Marshall, do you mind, I've reviewed this now, you can provide this copy to Mr. Blandino. Yeah.
Does it indicate where that email is purportedly from?
You need a blackout.
Oh, no.
And I asked Green Valley Psychiatric for any information they had, Judge, and they would not give me anything. I need to know from the back end what shenanigans might be played, especially by this district attorney, who's a disgrace to his grandfather, who was an honorable and
Mr.
ethical
Blandino,
man.
enough. This is not a court where we toss around disparaging remarks to anybody. This is a courtroom,
I wouldn't give
we're
them
going
if they
to
weren't
conduct
warranted.
ourselves with proper decorum in this courtroom.
Well, I.
And Mr. Blandino, enough.
Oh, I'm sorry, I thought it was.
I'm going to provide you a copy of the email so you can take a look at it.
Who is it purportedly from, Judge? And two, from and two? Okay, this is from Denise Baker. This is, one of the specialty court ladies.
Yes.
Well, why wasn't I being sent a copy of this?
Because it's a court proceeding, Mr. Blandino, and you're not a member of the court.
I'm an officer of the court as representing myself under a Feretta canvas, and I object to that. I am an officer of the court no less than
All right,
this bar
Mr.
attorney
Blandino,
is here.
take a minute to review that email.
I am. See, all this
Mr.
irrelevancy.
Blandino, have you finished reviewing the email?
No, I'm reading it, but I'm saying this stuff,
Okay, finish reading it and we'll talk about it.
this stuff relating to the 1211 is irrelevant as to this December 30 order. Unless you've got a time machine, I'll go back in time. Now, see, this is not true. If I got her on the stand, she would not say he didn't want that one. I asked if there was another one, that I had a conflict with that. I told him next available hearing was this 12/26, and that's the appointment that was made. The due date for the next report is 12/20. She never told me there was a problem with that. Just because there's a status check doesn't mean they can't set the appointment. You know that very well, Judge. And the defendant knew he would not be seen before his... Now see, she's testifying here if this is going to be introduced as some kind of evidence. I mean, this is more bogus than the Trump witch hunt impeachment. I told him the next available date that Dr. Capel had was Thursday, the due date, and the defendant knew that he would not be seen before this next due date. How does she know what I know?
Okay, so.
Dr. Slagle had no availability. When I set that 12/26, they said they'd call me back, and they'd make an appointment with Dr. Slagle. Courts do continuances all the time to fit schedules.
Sure, hold on.